Good morning and good afternoon, everyone. I'm Steve Joseph, the Vice President of Market Development at ShareVault, and I'd like to welcome our attendees today to what I'm sure, as I just mentioned, will be a very useful and eye-opening webinar. It's the 22nd in ShareVault's webinar series. Awareness and understanding of the relatively new alternatives to patent litigation is still quite limited, and because ShareVault data rooms are often used for intellectual property-related document sharing, we thought it an important subject to cover. Here's today's agenda. Most of the hour will be spent on presentation and the following Q&A session with a brief ShareVault overview in between while we're compiling audience questions for our guest presenter. In a moment, we'll get started, but first, a few housekeeping items. Because of the number of attendees today, we are unable to accept questions orally, so instead, please submit your questions through the question box in your GoToWebinar control panel. Also, I want to let everyone know that the slides from this webinar, as well as a recording, will be made available in the next few days, and we'll cover that a little bit more at the end of the session. Okay, now I'd like to welcome and introduce today's speaker, John Resick. As you can see, John is both a scientist and intellectual property attorney, and while his firm's focus is across a variety of technologies, John's 15 years of substantial legal experience is primarily across a variety of life sciences areas. Today, you'll get to see some of John's knowledge related to the Hatch-Waxman Act and the resulting new patent litigation alternatives. And with that, I'd like to welcome John. And John, thank you for being our guest presenter today. We're ready for your presentation.
Thanks, Steve, and my pleasure to be your guest speaker. Can you see my screen? I'm just not. Something just happened here.
You need to probably click the play button. There we go.
There we go. Okay. So, as Steve mentioned, this is going to be a seminar about the proceedings in the Patent Office, mostly inter-parties review and post-grant review, and I will be comparing them to district court litigation. After I do that comparison, we will discuss the PGR and IPR timelines, as well as opening motions, and then a short word on discovery, as well as some additional hypotheticals. As you'll see, I put a couple of hypotheticals in the talk itself, so I hope those will help enlighten you. The American Invents Act was initiated on September 16, 2011, and it established new trial proceedings to be conducted by the Patent Trial and Appeal Board, which is also known as the PTAB, and they are conducted in the United States Patent Office. The new trial proceedings include the inter-parties review and the post-grant review. The inter-parties review, as you can see, was available earlier than the post-grant review. And as of October 16, there have been 1,900 petitions filed for the IPR. It's become a very popular proceeding. Only 2 for the PGR, and that partly is because it's recent, and partly also because it only applies to patents which were filed after March 16, 2013. 384 IPR petitions have been terminated, 5,000 patent claims have been reviewed, and 999 have been found to be invalid. So it's popular, and if you are the petitioner, that is the opponent of the patent, it is quite effective. So here is a comparison between the IPR and the post-grant review. So, as I mentioned, the post-grant review is only effective as of March 16th, and at that date, what happened was that the United States went to a first inventor to file patent system. Post-grant reviews only apply to claims which are first inventor to file. In comparison, the inter-parties review applies to any patent claim, both those filed before the March 16th and those that are filed after. And since any patent claim can be in an inter-parties review, of course, many more, those have been going on for longer, and they have been, there's a lot more record on them. So the threshold for the petition, basically, if you want to move forward with these, you have to file a petition which is reviewed by the PTAB, and in deciding whether or not they're going to go forward, you can have, they have to weigh the evidence that you present. And if they decide that it's more likely than not, basically, that there's a greater than 50% chance that one of the claims is unpatentable, then they will go forward with it. So that's the threshold, and essentially it's the same for the inter partes review. The wording is a little bit different. In the inter partes review, they call it a reasonably likelihood that the claim is unpatentable. But basically, it's the same thing. That is, that if there's a greater than 50% chance of unpatentability, the proceeding goes forward. Another difference between the PGR and the IPR is the filing deadline. The PGR has to be filed within 9 months of the time of the patent issues, and whereas the IPR is filed after that 9-month period. The PGR can allege any basis of invalidity in the statute under 101, 102, 103, and 112. That is, utility or abstract ideas are a basis for invalidating a patent. That's 101. 102 is anticipation. 103 is obviousness, and 112 is sufficiency of the disclosure. Each of these, of course, are sections of the patent statute. And the difference with IPR is that it only involves 102 or 103, that is either anticipation or obviousness, and those arguments can only be based on patents and publications, whereas the arguments for invalidity under the PGR can include such things as prior use or sale, which of course are not documents. So you can allege, for example, that a compound or a invention was sold over 1 year prior to the filing date of the application, and that would be a basis for invalidity in the post-grant review, but it would not be a basis under the inter partes review. So here's a first hypothetical, and what it emphasizes is that you can have a PGR which can be followed by an IPR. And basically, in this case, the patent issues on January 2nd, 2015, and it has 30 first-to-file claims. Party A here can file a PGR about a month later. It's within the 9-month period, and allege anticipation based on the use of the invention. Here, the invention is a therapeutic antibody. The PGR will finish a year later, and if the claims are found to be valid, another party can initiate an IPR at that point, alleging that invalidity based on 2 prior art patents, and it could be an obviousness or anticipation. So in this case, what you see is that the IPR actually was filed again after the 9 months stay, but it had to be delayed until the PGR was finished. Okay, now another big issue here is the Estoppel Effect. So basically what this means is if you bring a basis, a ground for invalidity, or you have a ground that could have been raised in a PGR or IPR, then you are stopped from arguing that a second time. And the estoppel applies once the PTAB issues a written decision. And it applies to any argument that you might bring before the USPTO or in a district court civil action or in the ITC, the International Trade Commission. And it applies to the petitioner as well as the real party of interest, which might be an exclusive licensee or the owner of the patent, and anybody who's privy to that, to the real party of interest or petitioner. So that's an estoppel, and it's something that's very important to keep in mind because it may limit your future options if you're the petitioner and you decide to raise an issue or bring a petition. Now here is just a comparison between the civil action and the post-grant proceeding. one of the most important things is that the standard of proof for invalidating a claim in the civil action is clear and convincing, whereas it's preponderance of evidence in an IPR or PGR. Now, preponderance of evidence, again, goes back to that idea of greater than 50%. So if it's more likely than not that a claim is invalid, that's preponderance of the evidence, and you would say that the claim, it would be invalidated in the patent office, whereas a civil action is a much higher standard. It's clear and convincing, and it's not without a doubt, or as you might find in a criminal case, but it's about 80%. So if you think of preponderance of the evidence is over 50%, clear and convincing would be, say, over 80%. It's a higher burden that you have to clear. And as you can see, the PGR and IPR would be barred. The petitioner would be barred from bringing these if they had filed an earlier civil action. So, if they had alleged in a declaratory judgment that the claims were invalid, they couldn't thereafter bring a PGR or IPR. However, a counterclaim does not count as bringing an earlier petition. So if they were sued, if the petitioner was sued and he then for infringement and he then alleged invalidity of the claims on which he was sued, he could still bring the PGR or the IPR. Now, so this is a slightly different situation, and here I've essentially copied the language of the statute. And that is that the petitioner can file a civil action on or after the date on which they file the IPR. So that is the reverse of the earlier case. So they can't file the civil action before, but on or after the date in which they file the proceeding in the patent office, they can file the civil action. And that will be automatically stayed unless there are three events which will stop the stay. The patent owner can lift the stay. He can go forward with the civil action. He may allege infringement in a civil act as a counterclaim in the litigation which has been brought by the petitioner, or the petitioner may move to dismiss the civil action, in which case, of course, that would lift the stay because there would be no civil action. And one last point is that the proceeding, the IPR is barred if it were to be filed more than 1 year after the petitioner is served with the complaint. So if there's a litigation going on, you have to do it within 1 year of a complaint alleging infringement. So again, here is a cartoon illustrating the idea. The petitioner initiates a civil action on December 12th. Then in January, he would be barred from requesting an IPR. In this case, another case, the earlier filed IPR does not bar the civil action. So in this case, the petitioner filed the civil action in December, and I'm sorry, he filed the IPR in December, and then he brought a civil action in January. The action is stayed, but of course, the owner may lift the stay, which is what happened, which is what that last box shows. In this third hypothetical, the patent owner initiates a civil action alleging infringement. Party A files a counterclaim that the claims are invalid, and the petitioner, or in this case, he would be the defendant because he's accused of infringing the patent. He would be the petitioner. He could become a petitioner and file for an IPR alleging that all the claims are invalid as under the IPR standards. So here I'm going to go over the timeline and some of the opening motions. what happens, you can see, is that what opens the proceeding is that a petition is filed, and this is followed by a preliminary response. The patent owner gives a preliminary response to the petition, and then there's a decision based on the petition about whether or not to go forward. If the PTAB decides to go forward, the patent owner can respond to the petition, and he can also amend the claims. The petitioner then has the opportunity to file a reply to the response and to oppose the amendment. And then the patent owner has an opportunity to reply to the opposition by the petitioner. And then there are some motions to exclude. There's an oral hearing, and then there is a written decision. And if either party doesn't like the outcome of the written decision, they can appeal to the Federal Circuit. Now, what you'll notice is that there's an appeal to the Federal Circuit from the final written decision, but you cannot appeal a decision not to file a petition. So that decision is unappealable. Something to keep in mind. Now, you also, so if you don't, basically what that means is that you can't put everything, if you don't put everything in your petition, you could be stuck if the PTAB doesn't grant the decision. If you're a petitioner, you want to load up that petition with all of the evidence that you possibly can to convince the PTAB to go forward with the proceeding. Now, the 12-month period, which I mentioned before, this is a very quick proceeding. It's much shorter than a civil proceeding. The whole thing is over within 12 months. That 12-month period is marked from the time the decision is made till the time there's a PTAB issues a written decision. This 12-month period can be extended up to another 6 months, so it can go up to 18 months. But it's relatively short, and it's much shorter than would be in litigation, which of course could go on for several years. So that is the timeline. Now, what does the petition contain? The petition contains a certification that the patent is eligible for a post-grant proceeding. That is a PGR, IPR. It certifies that the petition is not barred by estoppel. It identifies the real party of interest, that is the assignee, the inventor, or a licensee, an exclusive licensee. It identifies the claims that are being challenged, and it provides a claim construction. One of the advantages of these proceedings is that you have a much broader claim construction in an IPR or PGR than you do in district court, because in the PGR it's based on the specification, and you get the broadest reasonable construction of the claim based on that specification, whereas in a civil case, the construction would be much narrower, and it would be based on prosecution history, and the claims might be construed to be much narrower than the broadest reasonable construction. The petition also includes evidence such as declarations, and test data, and patents and publications that are being relied on, and the petition is always publicly available. So, in terms of the patent owner's preliminary response, the response, excuse me, I'm hearing some background noise. The response is basically a legal response, that no testimony is presented. You don't present any evidence by a declarant or an expert that something is, invalid or shouldn't be brought. And in fact, just because the patent owner decides not to file a preliminary response, does not mean that there's any adverse inference drawn from that. So he can pass, and the decision will be based solely on the petition rather than anything that the patent owner files in the preliminary response. The kind of thing that generally would be would be brought would be an example for that the petitioner is barred from seeking review because he may be stopped, or because he filed an earlier civil action, or that the references are not prior art. So the next thing is this decision by the board in the petition. And as I think I've said a couple of times, that the standard for initiating is the reasonable likelihood, or more likely than not, depending on whether it's an IPR or a PGR. And basically, it's a greater than 50% chance that at least one of the claims is unpatentable. And this threshold for initiation can also be satisfied by showing that the petition raises a novel or unsettled legal question. So there's a slide here which is missing, which is the response that the petition that the patent owner files after the decision is granted to go forward with the proceeding. The response would be the same kind, would contain the same kind of information as the original petition. There would be declarations filed by experts, as well as any other evidence that would support a patentability of the claims. In addition, there's one thing to note is that the claims can also be amended as of right by the patent owner. So if he believes that the claims have to be narrowed because, in fact, the petitioner has shown invalidity, but for a broad claim, but that a narrower claim would survive, he can request an amendment at this point. That's a difference between what goes on in district court. You can't amend the claims in district court. If you wanted to get an amendment, you'd have to go in and go back into the patent office. So here are some examples of cases which have been decided. These actually were decisions which were reached during the process of an IPR, and they're posted on the PTO website, sort of for the general information to the general public. And this was just to inform the public as to what would go into a decision by the board not to grant a petition. So this involved two pharmaceutical companies, Prism and Shunhua. Shunhua is a Japanese pharmaceutical company. They were the patent owner. And they had a patent on chemical compounds which mimic small peptides. Prism filed a petition arguing that that the claims that covered these patents these chemicals were invalid. And basically, Prism presented the same arguments that had been presented during prosecution and examined during prosecution. And the PTAB said that, we have the discretion whether or not to accept or reject a petition. And when you present the same arguments that have already been considered by an examiner and have already been prosecuted, then we're not going to listen to them again. And you have to come up with some sort of new evidence if you want to go forward with a PGR or IPR. This was another decision by the board along the same lines, so they decided not to grant the petition. This was a Unilever versus Procter & Gamble. It related to an anti-dandruff shampoo composition. Unilever filed a petition that sought review of 33 claims. The review was granted on some, but not all of the claims. And then they filed a second petition challenging the patentability of the claims which weren't granted review, and essentially under the same grounds as had been cited previously, although they added some new prior art. And the PTAB denied their petition, saying that there was basically no new argument or any evidence that was presented that couldn't have been known or available at the time of the first petition. And there was basically no reason for them to consider the petition on the second petition on these other claims. So the petition was denied, and no proceeding was initiated. Now, this is a decision by the board to denial entry of an amendment, and as I mentioned, when the patent owner files a response, they can also amend the claims, and that occurs, of course, after the decision has been made to go forward with the proceeding. In this case, Bergstrom's patent covered an air conditioning system, and they proposed a number of claims, of amended claims. They had 10 alternative claims for Claim 1 and 13 for Claim 17. And basically what the statute says is that the patent owner can propose a reasonable number of claims, and the presumption is that the challenge claim will be replaced by one of the substituted claims, or the proposed substituted claims. And the PTAB dismissed the motion to amend because they said basically that Bergstrom hadn't articulated a contingency under which the alternative claims would be entered, and therefore there were too many, and the petition was the amendments were denied. So the next topic is discovery, and that's just what you see here is a timeline of the PGR and IPR discovery. And basically what happens is that after the PTAB makes a decision on whether or not to go forward with the petition, I'm sorry, they assume they make a decision to go forward with the petition, the patent owner gets an opportunity to respond and amend the claims. In between those two events, the patent owner has a discovery for 4 months. And after the patent owner files a response, the petitioner has an opportunity for discovery. And then it flips back over to the patent owner for reply to the opposition. And then if there's any new witness presented during the reply or testimony, the petitioner gets a chance to cross-examine that person. So discovery then flips back to the petitioner. So there's this alternating timeline for discovery. Now, the way I think of this discovery is you have this rule, is you'll see that you have what's called routine disclosures or routine discovery, as well as additional discovery. And the routine disclosures are very narrow for these proceedings. They're much narrower than you might get in a civil proceeding. Whereas the additional discovery, if you get that, would be similar to the kind of discovery you might get in a civil proceeding or district court. Routine disclosures include exhibits cited in the petition, response or reply, cross-examination of declarants such as experts, and relevant information that's inconsistent with the position advanced by a party. Additional discovery includes things such as the kinds of discovery you might get in a civil procedure. The standard for getting that, such as deposition of witnesses which are not declarants. The additional discovery would be granted only if it's in the interest of justice for an IPR, or a PGR would have to meet the good cause standard. Now, I have done quite a few interferences, and good cause is a very high standard. Interferences being another procedure in the patent office. The good cause standard generally means that if you have a heart attack, that's good cause. But short of that, short of something dramatic, you're not going to get additional discovery. So it's going to be a very tough thing to go beyond routine disclosures. And here was another decision by the board recording denial of a discovery motion. This was a case of Cuso versus Garmin. and the patent here related to a speed limit indicator. And Cuso filed a discovery request, an additional discovery request, which sought information that was inconsistent with the position of Garmin. And the PTAB said that the kind of discovery that Cuso was seeking was essentially the same as one might find in a district court. And basically, Cuso was casting this wide net over and seeking information which would be inconsistent, but which Garmin might not know about. And they said essentially, this is basically a fishing trip, and it didn't meet the interest of justice standard because it was really directed to the mere possibility of finding something useful, and that they needed a threshold amount of information if they were going to grant a broader discovery motion. Okay, so there are a couple of additional hypotheticals that I wanted to present to you. This is basically similar to essentially it's the Fresnius case, which was actually a re-exam case, but I've recast it here in terms of a IPR case. So basically what happens in that case is that there's a patent that issues, in this case we say it's to a therapeutic antibody, and the owner of the patent sues, which is Party A, sues Party B, who's the defendant, and he sues him for infringement of using this therapeutic antibody. Party B, files a IPR. They do so January 5th, 2014, which is in the 1-year period after the complaint has been filed. And so this litigation goes on, and then on October 30th, 2014, the district court finds that the claims are valid and infringed. And Party B, who's the defendant, goes on to appeal to the Federal Circuit. The PTAB, after the district court decision, finds that the claims are unpatentable or invalid. And the result is that the Federal Circuit decides that the claims are invalid, that the PTAB basically called the shots. And as I said, this was essentially a re-exam case, but there's no reason why the same logic wouldn't apply to an IPR. Now this is an example of a generic drug company, or what happens in a Hatch-Waxman case. Basically, there's a new compound which is invented, it's by drug X, and drug X is launched as a treatment of high blood pressure. Now, it's a new chemical entity, so when you have a new chemical entity, you get 5 years of exclusivity, and this is this exclusivity is granted by the FDA. So it's not really nothing to do with a patent, but it means that nobody can compete with you on that new chemical entity for 5 years. But during that period, there's no reason why a generic company could not file an IPR which challenges the claims of the patent that covered drug X. And if they were to prevail, then that patent would be invalid. And in that case, the only thing that would protect the brand name company would be the 5 years of exclusivity. And so I think this is something to keep in mind. It means that a brand name company needs to protect themselves if they want to if they don't want to have their patents challenged by an IPR, and the generic companies should be aware of how these things will play out. So that is the summary of my talk. That's the talk. So thank you very much.
John, thank you for your very enlightening presentation. While I'm sure many people are glad to see the new alternatives, these alternatives are certainly not simple, and choosing the best option clearly requires some careful analysis by companies and their legal counsel. We're not going to be compiling the questions for John that have been submitted, but it's not too late if anyone in our audience still has some questions they would like to ask. So please just go to the questions box in your GoToMeeting control panel and enter them there. And while we're compiling the questions, John Napoli from ShareVault is going to briefly show you a ShareVault configured for legal needs. This will illustrate the point that John Resick made about documents. You know, that there's obviously a large volume of documents that get shared during these petitions and the activities around the IPR and the PGR, as well as the civil litigation. So, John?
Thank you, Steve, and thank you, John Resick. My name is John Napoli, everybody. Thank you again for joining. Good afternoon, good morning, wherever you are. And I'm a member of the sales team here at ShareVault. I'll be walking you through a very brief demonstration of ShareVault's virtual data room platform. So ShareVault is a fully featured virtual data room service. The platform is designed to efficiently and intuitively support the dynamics and workflow of litigation support, IP licensing, and partnering transactions. If we're signing in as a user right now, we're signing in into our attorney's ShareVault account with a project already underway. You'll notice the documents are displayed and organized as if this was a legal application. These documents are a sampling of some legal documents under review. ShareVault supports large files and considerable volumes of large files extremely well. ShareVault can also handle TrueCrypt files, which are often used in applications such as these. So here we're looking at our user Jack, our fictional user, exploring the documents under review. Once that's complete, what we'll do is we'll show you what the administrative role looks like for someone who is running an application like this. So we'll switch here to an administrative view and show you the responsibilities. If we start at the admin tab, ShareVault equips the admin with a broad range of document security policies to help them prevent unwanted distribution of documents during the legal review process. To that end, ShareVault can keep documents in encrypted PDF. ShareVault can also prevent printing, saving, and copy-paste. There is configurable and dynamic watermark on every page of every document. Navigating over to the Users and Groups tab, ShareVault's permissioning tool empowers the admin with the ability to control and select folders and documents that it wants to share with attorneys. ShareVault's flexibility and granularity enables the admin to permission at the folder, subfolder, and document levels. ShareVault's privacy tool helps the admin to keep their data room participants' identities from becoming mistakenly revealed during the legal review process. Finally, the Reports tab. During the project, the admin can research and monitor the user's and the user attorney's interests with help of ShareVault's summary report. The activity list is an audit trail of user activity that can be defined by time and activity. We can track our user Jack's activity from earlier and see the specific documents Jack had under review. So again, this is a very brief demonstration, and that concludes the process here. If anybody would like to see a more in-depth and personal demonstration of our services, please contact ShareVault Sales. Many thanks.
Thanks, John. We're now ready for the Q&A session with John Resick, and we'll try to cover as many audience questions as possible during the rest of the hour. However, if we don't get to your questions, we'll forward them on to John for him to respond directly. Also, since a few people have asked questions about getting copies of the slides, they will be made available for downloading in the next few days, and a recording of this webinar will be on our website shortly as well. So we invite you to come back to the website and review it again. As we mentioned earlier, there's a lot of complexity to this, and I think it bears going through several times. John, one question that's come up here relates to the small number of PGRs that have been filed, and whether that is it indicates that it's not likely to be a very popular path to be used, and that it could be the choices really come down to IPR versus civil litigation.
Yeah, I think it's too early to say. Because, as I mentioned before, the PGR only applies to first-to-file patent claims, and there have not been very many first-to-file patents have issued. So March 16th, 2013 was the day when the first-to-file became effective. So everything that was filed on March 16th or after was first-to-file application, and there's really been only a year and a half between that date and the present. So there are very few first-to-file claims that are out there. I think the two cases were expedited cases. They were fast-track cases, which issued very quickly. So we'll have to see how that develops. I mean, certainly you might present some cases before district court. There may be some arguments you want to make before district court that you wouldn't want to make before a patent judge, although a patent judge, arguably, if you're the petitioner, is a better audience because they not only are they lawyers, not only are they patent lawyers, which a district judge is not, they also have a technical background and are more likely to understand your invention, whereas the district court judge, may be a political science major and may struggle with the technology. So we'll have to see. I think that the PGR could be quite popular.
Okay, thank you, John. Another question relates to the PGR and IPR examples, or the examples that you gave, and whether in one industry area, life sciences or pharma, you gave one example in the pharma area, whether that's more likely, whether you think this will be a more popular process is the essence of the question, for certain industries than for others, or do you, what you've seen and in your experience, do you think it's applicable to a variety of different technology areas, whether it's high tech or others?
So far, there have been more high-tech PGRs, rather IPRs, than biotech or pharma, by a substantial number. And I'm not sure why. I think that there may be because there are more high-tech patents, and it may be because a lot of the patents are just not worth litigating. Whereas the patents that are used are in the life science area, there are fewer patents, and they tend to be more valuable. I mean, if they're worth litigating, they're worth a lot of money, and so people may be more comfortable bringing the civil action. What I have seen is that these are used in conjunction, in the life sciences, they're used in conjunction with civil litigation. So, for example, one might argue obviousness in an IPR PTAB, but they would argue written description before a district court judge.
Okay, thank you. When you sit down with a client, can you describe a little bit of the analysis between the litigation path and and the alternatives, the Patent Office alternatives that you've described here, you covered some of the criteria, but how does that work when you are talking to a client?
Well, I mean, I think the things to consider are if you are a petitioner, your chances of winning are higher in the Patent Office. But you're also, you're limited by the amount of discovery you can get. And I think that because it's an expedited process, they want to really focus on, they don't want to expand their discovery. And so if you think that there's a smoking gun that may be known to the patent owner, then you're more likely to do a civil litigation. Whereas if everything you have is based on prior art and there's really nothing else on the public patents or publications, then you might be well advised to simply go by the PTAB, or by the IPR, PGR, or the IPR.
Another question here relates to the IPRs, because there's a substantial number of those. What's the outcome of those been so far?
A lot of them have settled. I think I presented the statistics. The statistics were that there have been 5,000 claims challenged and 999 have been found to be invalid. The outcome tends to be that if you go all the way to a decision, the chances of invalidating the claim are high, about 30%. A lot of these are settled prior to a written decision. I actually didn't mention that the settlement is possible, so the two parties can agree not to go forward. In which case, so in any case, the chances are good that a claim will be declared invalid.
Okay. John, I think we're going to wrap it up at this point. I'd like to thank you again for presenting and for the very useful information you've provided. I'd also like to thank our audience for their attention, and invite you to check out ShareVault's website for the schedule on future webinars, along with seeing recordings of our previous webinars. And there are some on on the ShareVault website that actually also relate to intellectual property. As a quick reminder before we close, the recording will be made available shortly, and as attendees today, you'll receive an email on how to get copies of John's slides. So on behalf of John and my colleagues at ShareVault, I'd like to wish everyone a very good rest of the day, and thank you for joining us today. Thank you, John.
Thanks very much.